Should I put my kids on my bank account? Let's jump into this surprisingly complex area of law. I'm Zach Anderson of Valley Estate and Elder Law, and I'm going to walk you through it here today. So there's a couple of different ways you can put your kids or someone other than your spouse on your bank account. And whatever path you choose with regard to that, you need to know the ramifications of each. We're going to walk through them together right now. First is joint ownership. You can add someone as a joint owner to your bank account. I wrote this in red because usually it's not a good idea. Of course, this is going to depend on your family, your situations, goals, judgments, values, assets, lifestyle, things like that. But generally, this is not a great idea because one, we could have just made a gift for Medicaid purposes, for gift tax purposes, which could come into play in a probably small number of situations. But one thing, we could have just made a gift. Two, they're joint owner now. They could withdraw all the money and you could be in trouble. If they become incapacitated, if they have to go on Medicaid, if something happens to them, maybe they really need the money. Well, you could be in a sticky situation because they're just as much of an owner of the asset as you are. What if they die? What if their spouse gets it? What if their kids get it in a will or something like that? Their interest in that bank account. What if their kids are minors or have a disability? This is generally not a great idea. You need to know the ramifications of doing that. Let's talk about a different way to have your kids on a bank account, and that is if they are sign only. That is, they have the ability to sign checks from the bank account. They have the ability to view the bank account, but they're not a joint owner. This is often a good idea. I can't give a blanket endorsement, of course. Remember, this is a one-way video. I haven't met you, okay? Generally, sign only is a lot better of an idea than joint ownership. I actually recommend it to some of my clients who are more advanced in age. Just have that trusted adult child or that trusted friend who's probably a financial power of attorney agent for you as well. Just have them watching. Make sure we're not sending money somewhere that might raise a red flag, just to check on things. It's often a good idea. So regardless of whether you end up doing either of these, you need to know that these are very, very different, okay? The third way you can have a child on a bank account is if they are your beneficiary. This is sometimes referred to as a TOD, which stands for transfer on death, or POD, which stands for payable on death. This means that person gets the asset when you pass away, and they generally get it outside the probate process, outside of a will or trust. Doesn't matter what a will or trust says, with some exceptions for certain family members. Generally, if they're your beneficiary, they get it when you pass away. So, should you have your child as a beneficiary on your bank account? This one, it's going to depend. So the first thing we want to look at is how prepared is your beneficiary to get those assets? Are they likely to be sued? Are they a minor? If they're a minor, they're very unprepared to get the asset. They won't be getting the asset. They'll be getting a conservatorship instead, which we generally try to avoid. Are they a good money manager? Are they going to have tax issues with getting that money, getting an inheritance from you? So we want to look at preparedness before we just slap a kid's name as a TOD or POD on a bank account. And then the second thing we want to look at, I sort of hinted at it just a wee bit earlier, is asset protection. If your bank account has $5 million in it and your child is the beneficiary, hypothetically, they get the $5 million, their name goes on the account or they get a check for the money, that money is theirs at that point. If they get sued or divorced the next day, that money is on the table for a creditor. We can do a little bit better than that with planning. It's more sophisticated planning. It's fairly robust planning. It takes a lot of work from you and a fair amount of work from me as well. This can provide asset protection if we don't leave it outright. So in other words, if we use some kind of trust to be the beneficiary of a bank account, or perhaps retitle the bank account in the name of the trust, we could protect that money after you're gone from someone suing your child. So that someone suing your child, like a divorcing spouse or someone who's suing them in their line of work, or someone who's suing them because they had a lapse in judgment and they were texting while driving. That person is not going to be able to get the assets in the trust if we do things right. So asset protection is one thing we want to look at. We want to look at the amount in the bank account. If it's $5,000, probably okay to slap them as beneficiary on there, put their name on there. But if we have a lot of money in that bank account, and whatever a lot is, that's up to you to decide. If we want to protect that, then putting a child's name on the beneficiary or on the bank account as a beneficiary might not be the optimal thing to do. So there's 3 ways you can add a child to a bank account. Joint owner, heed my warning. Caution is warranted there. Sign only, I like that in a lot of instances because of the oversight it gives. And then beneficiary, that can be good. It can also be inappropriate for certain clients. That's going to depend on mostly these 2 factors. And then probably I could have put amount here as well, because that factors into the analysis too. But now I hope you know that there's at least 3 ways to add a child to a bank account. And now you know the positives and negatives of each. And if you need help with determining which one of these is right for you, contact an experienced estate planning attorney in your area. Thanks for watching.